Public interest lawyer Jiti Ogunye joins us now. Thank you very much, Jiti Ogunye, for agreeing to be on this day live, this Sunday talk show today, here on the Arise News channel. Okay, let's start with the major issue about ASU strike. ASU says, okay, it's now obeying the Court of Appeal. The Court of Appeal responding to the National Industrial Court decision of September 21. And the Court of Appeal saying, obey first and then complain. Stay of execution withdrawn by Femi Falana, SAN motion, withdrawn. Fine. But go and respect the ruling of the lower court. And then you can come back after the status quo antebellum has been observed, and then present your case on appeal. What are we dealing with here? Legalists, or the fact that we need to save the education system?
Well, thank you, Dr. Abadi, for inviting me to this show. And I also want to extend my gratitude to members of your panel, who are eminent Nigerians, who always usually dissect these burning issues week to week. Now, it does appear to me that there is a political consensus on the part of the political and judicial establishment to terminate the strike. The strike, let's face it, had become inordinately long, and parents, students, everybody was looking for a way to end the strike, even though many wanted the strike to end after all the issues that led to the strike will have been resolved. Nigerians can recall that after the strike had been existing for about 6 months, the Honorable Minister of Labour referred the dispute to the National Industrial Court, which indeed was the bone of contention at the National Industrial Court. Because if you look at the Trade Dispute Act, there are elaborate provisions governing trade disputes and the resolution thereof. First, once there is a trade dispute, parties under the law are expected to meet and mediate inter-parties between themselves or amongst themselves. It were a tripartite issue. If mediation fails, then cancellation commences. The minister would then be expected to appoint a conciliator. And if cancellation fails, the matter would then go to arbitration, industrial arbitration panel, to which the dispute will be referred. And then once the IAP, the industrial arbitration panel, makes an award, and either party disagrees with that award and gives notice of disagreement or dissatisfaction with the award, the matter will then go to the National Industrial Court as an appellate court. And the reason is simple. When we're talking about trade disputes, labor crisis, and industrial harmony, the idea is not to immediately resort to litigation, which is adversarial. And so the law allows parties to meet, to have discussions and all that. Anyway, the minister waited for about 6 months, perhaps because other persons that the minister acknowledged recently, while thanking Nigeria, who intervened in the labor crisis, were intervening. And so it took the minister 6 months to refer the matter to not to the IAP as the law prescribes, but to the NIC, which was why ASU demurred. It was like a demurrer. It was an objection at the NIC that the National Industrial Court had no jurisdiction to entertain the matter. That dispute can only be referred, or could only have been referred, to the industrial arbitration panel first before it could then go to the NIC, and that therefore the court had no jurisdiction. But the NIC brushed that aside and wanted to continue with the litigation, which was why their lawyer, Femfal and Senior Advocate of Nigeria, filed that an appeal. Again, at the Court of Appeal, a new rule of law seemed to have been set, which was that being an interlocutory appeal, you need to secure leave. That's what Section 243 of the Constitution is saying, that you can't appeal as of right. You need to secure leave to appeal. And so an application was brought, a notice of appeal was filed, but it's not proper because leave had to be granted before you could say that an appeal properly had been filed before the Court of Appeal. But in granting that leave, the Court of Appeal, again, because of the Polukuku and judicial establishment consensus I spoke about earlier, then made it a condition that before the appeal would be deemed to have been properly filed, before leave could be granted, the ruling of the National Industrial Court, which was being appealed against, must be obeyed first. It may not appear logical, but perhaps it appears very logical to
no, let me come in here.
Because lawyers are familiar with conditional stay. After a judgment is granted and you want a stay of execution of a judgment, before that stay could be granted, that stay could be conditioned.
Two things.
This is the first time in my own experience that I'll be hearing about conditional grant of leave to appeal. Okay. But that's what the court decided, and therefore, ASU was constrained to obey the order of court, and eventually, ASU has called off the strike, following the intervention of the House of Representatives and the National Assembly.
Two things.
And issues largely remain unresolved, but that's where we are on the matter.
Okay, two things I would like to ask you. Are you saying, from my own understanding of some of the statements you have made, that the Court of Appeal took its decision in this particular matter in public interest with regard to public policy? Second, when you raise the issue of jurisdiction... No, just wait. When you raise the issue of jurisdiction, jurisdiction is fundamental to law, right? If you question the jurisdiction, which is an issue I will say bring up when we discuss the Nnamdi Kanu case, then of course, everything is null and void. So, what exactly are you saying?
What I'm saying...
Because if the National Industrial Court has no jurisdiction to hear the case in the first place, which is what the counsel of ASU pushed forward and talked about the arbitration panel and all of that within the purview of the Trade Industrial Act, then it means within the purview of, what's his name now, Lord Denny, in McFoy and USC. So it means there is no case. The federal government should not have gone to the National Industrial Court in the first place. Is that what you are saying?
Look, what I'm saying is that the federal government of Nigeria, and in particular the Ministry of Labor and Employment, didn't go to court for 6 months. They were having meetings and all that for 6 months. Didn't go to court. And what the Trade Dispute Act says is that once there's a dispute within 7 days, then there must be mediation. After that, there must be cancellation. After that, there must be reference to the Industrial Arbitration Panel. And ultimately, if an award is made and either party is dissatisfied, it ends up in National Industrial Court. Now, what I'm saying is that the federal government of Nigeria, instead of referring the matter after mediation, cancellation, to the Industrial Arbitration Panel, decided for reasons best known to it, although I can hazard a guess, because at that time, everybody was desperate on the government side to have the strike end, to end that strike. So the federal government of Nigeria went straight to the National Industrial Court, which I am contending that a matter of trade dispute like that, under the Trade Dispute Act, does not have an original jurisdiction to entertain such matter. It has to go through the IAP. That's the contention of ASU. And that matter won't be referred to it like that directly without the matter first going to the IAP. The National Industrial Court will lack jurisdiction to entertain that matter, because that would mean that the law was not being complied with, regardless of the fact that at a point the NIC, National Industrial Court, might have had jurisdiction to entertain the matter. And that issue of jurisdiction was raised at the NIC. But the court said, look, this matter is very important. It will get back to it later, continue. And also, and his legal team said, no, it's fundamental, it's foundational, it's a threshold matter. Decide it first. And the court had a ruling that no, it will be decided later, which was the matter that was then taken to the National Industrial Court. So that's what I'm saying, and this is plain enough. Now, the first question you posed on the issue of judicial policy, that's what appears to me to have undergirded the decision. And of course, we shouldn't be strike happy. The education system, particularly tertiary education, is paralyzed by strike. And it was unusual, 8 months. I recall that the longest we ever had in the 80s was a 6-month shutdown of 6 universities in the southern part of Nigeria by the military administration of Babangida following the 1989 anti-SAP demonstration. 6 months for those 6 universities. And everybody was saying that this is unprecedented. Now we had 8 months strike, starting on February 14th, a day that was supposed to be a day of love, but it happened to be a day of hunger on that occasion. Now, and so what I suspected is that the Court of Appeal was moved by consideration to have a situation in which the education system would be salvaged, and then made it a condition that the very ruling being appealed should be observed first before the appeal can be lodged. I'm saying that as a rule of law, this is the first time I hear that. I hear about conditional stay. If you are appealing against a judgment and you want a stay of execution, the court will say, yeah, you can come and appeal here, but we'll give you a condition. For example, monetary judgment, where the defendant is dodging paying or satisfying the debt. So the money can be paid into an interest-yielding account so that the winning party will not be prejudiced, that kind of thing. So that's why we talk about conditional stay. But in this case, it's a conditional grant of leave to appeal. I'm saying that it's a new rule of law for me, given the little law that I know. But I'm suspecting that that decision, since the Court of Appeal has the power to make a decision, being the final court in the matter, to take that decision the way it deemed it best, just to ensure that students then go back to school, and then thereafter, the matter, which is still pending, can then be given hearing and all that. And now, the strike, has been called off.
But you also agree with me.
We are back to school as it were.
But you also agree with me that in jurisprudence, some of the best thinkers said that the law is a social modulator, and that the law will not stand aside when it appears that there's an attempt to cause chaos. So it's not just about Austinian positivism.
That's why lawyers are called social engineers.
Okay.
In the manner of speaking.
So so we cannot blame the Court of Appeal if it goes in the direction that you have defined.
No.
But there are other questions. Let's move away from that. I would like your opinion on the Nnamdi Kanu case. The public has been inundated with these phrases. He was discharged. He was not acquitted. What's the difference between being discharged and acquitted? And in this particular case, the three-man Court of Appeal panel focused on the issues of jurisdiction and extraordinary rendition. So what is discharged and acquitted? What is, acquittal, in the purview of the common man? Because the ordinary man, part of what we do here is to explain the law to the common man, the ordinary man.
Well, the differentiation and splitting distinction that the Honorable Attorney General of the Federation, Abubakar Malami, Senior Advocate of Nigeria, was trying to draw was surprising to me. I had expected, following that judgment, kind of exhibition of sobriety, particularly given the weighty pronouncement of the Court of Appeal on the matter, particularly on the rule of law and fundamental rights of the subject, and the issue of competence of the charge. Now, after some initial perambulation and all that, Kanu was eventually confronted with a 15-count charge. Nigerians will recall. And the trial judge, Justice Binta Nyako, had struck out eight of the counts, a majority of the counts, leaving 7. And the court directed that the trial should continue on the basis of that 7, which was then the subject of the appeal, that the entire charge was incurably bad. And so the Court of Appeal, in its decision, pronounced on the remainder of the counts, the 7 of them, and struck them out, holding that the entire charge, counts-wise, disclosed no offenses. And that's very weighty, because we are talking about the Office of the Attorney General of the Federation, we are talking about its prosecution team, we're talking about the federal government of Nigeria, bringing a charge against a citizen. And that decision ought not to have been taken lightly. It's not a moot thing. It's not a moot and mock trial process. It's a serious matter bordering on terrorism. And so if the court found that the counts roundly were incompetent, it called for sobriety. Not that jumpy and immediate pronouncement as if the Honorable Attorney General were revising the decision of the Court of Appeal or interpreting it and then saying that this is what they meant. Now, directly answering your question, what is the distinction between a discharge and acquittal? An acquittal comes usually at the tail end of a criminal trial, when the court then will pronounce that this criminal defendant has been discharged, cleared of the offenses, and has been acquitted of them, meaning that he's been adjudged known guilty. While discharge is merely a discharge of a criminal defendant, particularly based on some technical stage that has been reached in the matter. For example, if a charge is withdrawn, or if a charge is struck out for non-diligent prosecution on the part of the prosecution, you have not reached that final stage when the court will then make such a pronouncement of acquittal. In this case, however, my opinion is that what the Court of Appeal did was to discharge and acquit Nnamdi Kanu regarding that charge, because there were no other charges. The court looked at the entire charge of 15 counts and pronounced those counts incompetent, and the charge in its entirety incompetent, meaning that As far as those counts were concerned, Kanu could no longer be retried on the same counts. The AGF may invent some counts tomorrow and say, I want to try afresh. The law is now better, clear. It's clearer than it was before. So we want to file counts that will hold and will disclose offenses. But that's a matter of speculation. As far as we know, there are no other charges. And so the entire charge was pronounced dead.
Okay.
And so as far as those counts were concerned, therefore, he's been acquitted of them.
Okay, can I come in here?
Now,
what the office?
The other issue.
Okay, go ahead.
The other issue, sir, is the issue of the pronouncement of the court on the rendition.
Yes.
Shorn of technical terminology, what's a rendition? A rendition is an abduction. The court is saying that, yes, he's on bail. However, in bringing him back to justice, you didn't follow the rule of law, i.e. the Extradition Act, the Interpol mechanism for the rearrest or arrest of fugitive offenders. You didn't toe that path, and he was brought back into the country to continue to face his trial. And what was worse, when his legal team, Nnamdi Kanu legal team, made those weighty allegations that he was abducted, that a rendition had taken place, and alleged that his rights have been violated thereby, the prosecution didn't contest that narrative. It's in the judgment. They didn't contest it. They didn't offer an alternative narration. They didn't deny those alleged facts. And so what was the Court of Appeal left to do? What was left for it to do? Other than to accept that as proved, that which was not denied.
Okay.
And so on the basis of that, the court pronounced that his rendition was illegal and unconstitutional, and that therefore he should be released from custody.
Two quick things.
Now, what I understand the Honorable Attorney General of Federation to be saying is that, and the National Security Council to be saying, because they've also weighed in on the subject, is that we are going to hold him back. We won't obey. But that would be illegal and unconstitutional.
Okay.
We'll find other ways either to appeal or maybe to file new charges afresh.
Okay.
That's what I understand that they are saying. But that would be illegal and unconstitutional because as of today, there is no appeal, there are no fresh charges, and the court has ordered that he be released. And we are talking about 3-4 days now since.
Okay, what is the public domain? Is the Office of the Attorney General saying that there are other issues for judicial determination? You recall that the Court of Justice Binta Nyako dismissed those charges in sections 1, 2, 3, 4, 5, 8, and 18 with regard to extraordinary rendition. And on the basis of that, the Office of the Attorney General is saying those were the issues at stake, and that the court, not being a Father Christmas, could not inquire into those other issues that are still for judicial determination, considering the fact that the accused person in this particular case, the accused person in this particular case became a fugitive. Is that immediately eliminated, mitigated by the error, as has been established, claimed, with regard to Section 15 of the Extradition Act by the Court of Appeal?
Okay, my response is that the decision of the Court of Appeal that I've read, the review there, I have not read the totality of the judgment, does not make any distinction that the Honorable Attorney General is trying to make. And I'm saying that the Honorable Attorney General cannot then make that distinction extrajudicially outside the court to then foist his own interpretation on it. The court ordered a release. That's in the judgment. The court pronounced that those counts disclosed no offenses, and struck out the charge. That was pronounced. So if the Honorable Attorney General is now saying that there's something else yet to be done by the court below, with the court has said, had no jurisdiction to try, not to talk of arraigning or making a distinction between 8 counts that were bad and 7 that could be saved and all that. What are we talking about here? It is usual in this jurisdiction, and this is very sad, and this is not an attempt to indict any public officer, that when matters happen like this, there will be a lot of scratching of head, running around, putting a bold face to a very terrible thing that has been done, and so on and so forth. Because let's face it, the office of the Attorney General of the Federation is a very important office. The decision to charge is not a decision that is taken carelessly. And so, if a court pronounced that counts are incompetent, this does not speak more to the professional superstardom of the counsel to the criminal defendant. No, it speaks more to the incompetence of those who brought the charge. Because you say charges are incompetent, what the court is implying thereby is that you didn't competently frame those charges. Let's face it. And that office is a big office. The federal government of Nigeria, vis-a-vis a citizen, is very powerful. It has all the resources. It has access to all the best lawyers in Nigeria. Okay? He can even farm out brief to outsiders to prosecute on his behalf. We've seen this done before. So if a court should pronounce that counts are incompetent, roundly 15, 1, 2, 3, 4, 5, 7, 8, and then later 7, then what are we talking about here? I think that the Honorable Attorney General should... it's not a matter for publicity stunt or for self-glorification or vindication or to say that, oh, this is different and all that. I don't like that kind of thing. Face it, the court has pronounced that these counts were bad, and then deal with it that way by ordering the release of the person. I know that usually when things happen like this, when the detaining authority is asked and pressed hard when and why, when it will obey the order and why it's not obeying, the first thing you told is that, oh, we are studying the order. The second will say, oh, it's not been served. Then we serve the order. Then they will say, oh, the Honorable Attorney General is going to advise the SSS or DSS, the detaining authority, and all that, while they then scramble and then look for a way to, further complicate the matter further. I would wish that the order is obeyed and then an attempt is made to de-escalate.
I get your point.
And perhaps use the opportunity for a rapprochement and for a resolution of the crisis in the South.
Jiti Ogunye,
where lives are being lost, and nobody likes that, and where blood is being shed unnecessarily.
Jiti Ogunye, I get your point. But as M.A. Latif has argued in his famous essay, Jurisdiction of Courts in Nigeria, he talks about subject matter, the person, the procedure. So it's not as if this is a straightforward matter with regard to jurisdiction. But of course, there are many opinions in this regard. And there are persons, including Michael Zekome SAN, who has argued in a published essay that perhaps the best way to resolve this is political, a political solution, not legalese. Because if we put 1,000 lawyers in the room, they will argue from every direction based on their own understanding of the legalese involved. But I want you to talk briefly about the fact that Justice Ariwoola has now been inaugurated, confirmed as the 18th Supreme Court Justice of, not Supreme Court, Chief Justice of Nigeria. And what is before him, given the circumstances of his emergence, his predecessor, having suddenly resigned, we're told, on health grounds, but within the public domain, we knew that it was not just about health. His brother justices were beginning to rebel. What kind of reforms will you recommend to
Well, Well, I think the way to start, first I congratulate the CJN on its confirmation as the substantive CJN of Nigeria. And by official records, he's bound to retire in 2024, November 11 or thereabout, coinciding with his birthday, when he clocks 70 years of age. So he has 2 years, as it were, to do all he can to make the judiciary better than he met it. That said, I think that the first place to start for him, if I were to suggest, is the unfinished matter of what led to the abrupt resignation of the former CJN from office. I don't think that insisting on that is not allowing sleeping dogs to lie or dredging up settled issues. We paper over fundamental problems too much in this country. If the attitude that is adopted is that, oh, this is my new era, I will look forward, I won't look back, that will not be doing justice to the matter. There were fundamental issues that were raised, and these were put in the public domain. It was alleged, though, that the letter was leaked, but there were, accusations and counter-accusations. I know that now that the CJN had left, the former CJN and the new CJN is on board, the attitude might be that let's just move on. No, we move on too quickly in this country. And so if the CJN is going to be taken seriously about its commitment to carrying out fundamental judicial reforms or driving it at the apex, because judicial reforms cannot be carried out only by CJN alone or the NJC alone. There are other institutions involved, including the legislature. I have given this example, for example, if reform were to be done with regard to accretion in the quality of the infrastructure, the judiciary, the area of digitization, the area of ICT and even buildings and all that. And this will implicate budgetary allocation, its increase, then the legislature will have to be persuaded. If it's not persuaded, then nothing gets done, and so on and so forth. So, yes, it's a shared responsibility, but it can be driven by a CJN that is reform-minded and is very keen on carrying out reforms. So, I would say that if it's to be taken seriously on that, how it deals with that matter, that unfinished matter, is going to be key. People will look at that to test his sincerity of purpose. And I believe that he will be sincere in dealing with such matters. And all these issues of judicial reforms are well known. People have talked about them. For example, the numerical strength of the Supreme Court. And I'm not immediately advocating for an amendment of the constitutional provision that says that you can have up to 21 justices at the apex court at any given point in time. But the truth of the matter is that since 1999, we've never had the full complement of all the justices of the Supreme Court. Now we have 14. 3 justices haven't left since May. Honorable Justice Ejembi Eko, Honorable Justice Mary Odili, and then the former CJN, Justice Ibrahim Tanko, had left. So we now have 14. With 14, we simply have 2 panels of 5 and 5 in ordinary appeals, and in constitutional cases, we do not even have just barely 2 and 2, 7, 7, 14. And in the other ordinary appeals, we don't have 15, so you can have 3. Meaning that all the appeals from the 20 divisions of the Court of Appeal, 20 divisions snaking their way to the Supreme Court, will have to be decided by these 14 persons, 14 eminent justices. Not to talk of the cases that come under the original jurisdiction of the Supreme Court, political cases that come and are determined more quickly, and so on and so forth. So this impacts on the longevity of cases in the Supreme Court, 3 years, 4 years, 5 years for appeals to be decided. And so from the human capacity perspective, they will not be able. So something has to be done quickly about this. We've talked about the issue of refederalizing the judiciary. We talked about it the last time. We talked about the issue of remuneration of justices that have to be very fair and, the sufficient motivation for them to do their job. Now, in the intro, the CJN was quoted to have, and I heard him clearly, was appealing to politicians to allow justices to do their job. I would rather want him not to make that appeal. Politicians will do what they want to do. In some cases, we've been told that what the politicians want to get, particularly in political cases and election petition cases, is judgment at all cost. They are not interested in justice. So if judicial officers know this, they are the ones who have to protect their territory. They are the ones who have to remain incorruptible. They are the ones who have to ensure that ethical standards are maintained at all costs. They are the ones to rebuff. As it is said in local parlance of the Yoruba proverb, Agbara ojo lo onilewo, onile ni odigba fun. A rain flood will not mind demolishing your tenement. So you are the one, before the flood comes, that will have to provide embankment and pillars and all that protection, buffer for your choice property. So politicians will do, appealing to them, propitiating them will not do. So judges must exercise their powers to ensure that justice is done in all cases to all manners of men. And I wish him well. The task is before him, is cut out for him. And I think that he should make a mark in these 2 years, which can then be a basis for further improvement in the judiciary. There are a number of, those issues are there, they've been debated over and over and over and over again. And I think that the task is just cut out for the CJN, leading his NJC and his brother judges at the Supreme Court to ensure that down the line of the pyramid, judicial pyramid, that everything is done to ensure that the judiciary wins its trust.
Okay. Okay.
So that our people continue to repose confidence in the judiciary.
Okay. On that note, Jiti Ogunye, I would like to thank you very much. I mean, and you raised a point that is of concern to many members of the legal community about the depletion of justices at the Supreme Court, which is the window story in this day newspaper today. Some people are even saying, look, can't Nigeria possibly go beyond the constitutional limit of 21 and have 30 judges? The Akisha judge, I think, who made the point that, look, it's not just about increasing the number. You have to make sure you give them accommodation, you pay them well, and you take care of them. All of this is part of the reform that people are asking for. But thank you very much. If I
must just intervene laconically, increasing the number will not do, because it will create another problem.
Okay.
The problem it will create is that if you have like 4 panels, 5 panels at the Supreme Court, and you assume that they will be able to better handle all the appeals, it will mean that a minority would still be taking the decision of the Supreme Court. And Chief Ganifa campaign against it. In the United States Supreme Court, you have 9. 9 of them render judgment at the same time. So you have a minority of 5 delivering a decision of a court of 21 or 30 or 40, as the case may be. The solution is in refederalizing. Shed the Supreme Court of its decision and create regional Supreme Court to take ordinary cases like murder, like whatever, so that constitutional cases of importance can then go to the Nigerian Supreme Court, as the case,
in the United States. That's the
solution
States, particularly.
that I see.
Thank you very much, Jiti Ogunye, for joining us.